not necessarily those of this station, its staff, management, or sponsors.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Good evening, South Florida. Do we have a treat for you tonight? We get so many emails regarding our first show each month. We should just call it the K. Bender Rimbaum Show. We literally get probably at least 50 to 60 emails a month of questions that people want us to ask. And a lot of those emails said, why don't you do the show more often? Well, we have finally found a way, not every week, but the first and last Thursday of the month is going to be the K. Bender Rimbaum Show, basically. Though it still asks the experts, but we are so excited about this because it's such a great show. And on the first Thursday of the month, we always have people on the phone waiting that we couldn't get in. And we also had questions that you sent in that we couldn't get in. We just didn't have enough time. So now, not only the first Thursday of the month, of course we're on from 6 to 7, but now the last Thursday of the month, we are going to have the K. Bender Rimbaum Association, Community Association Law. And one of our experts, if you've been watching the show long enough, you will probably recognize him. Listen, and we have two guests, not one, we have two, which is unheard of. But let me start off. I want to introduce you to our two guests tonight, Michael Bender, attorney Michael Bender, and attorney Peter Mullengarden. Good evening.
Hello.
Good evening.
Michael, how long has it been? A couple of years? Yeah.
It's been a little while.
Been a while.
I let Robert have the spotlight.
Yeah. Okay. Well, anyway, we have got so much we're going to talk about. We've got your emails. If you'd like to call into the show, the phone number here is 888-565-1470. We are here to take your calls, your questions regarding HOA and condo association law, and we've got a lot of questions tonight. So I guess, Michael, we'll start off with you. Tell everybody about the firm because we're going to have a lot of new listeners on tonight.
Sure. Anyway, well, Steve, it's good to be here. Peter, nice to see you.
Same here.
And K. Bender Rimbaum we are a community association law firm. Our practice focuses on representing community associations. Hopefully, if you're calling in from a condominium, HOA, cooperative, or the like. And we, as general counsel for our clients, we handle all aspects of that representation, from day-to-day management, from legal issues on a day-to-day basis, interpreting your covenants, amending and updating your covenants, enforcing your covenants, to assisting with the collection of delinquent assessments, to addressing simple to complex litigation matters, and everything in between. We pride ourselves on our availability, our accessibility, our responsiveness. Peter and myself are two of 9 of our attorneys who are board certified specialists in this area. We also, as you know, Steve, and hopefully people listening know, we're very big on education. We offer a lot of education, both virtual and trying to get back to some live education. We are also very active in legislation, both through the Florida Bar as well as through CAI's Florida Legislative Alliance. And that's a little bit about us and who we are. And I just want to say it's nice to be here. And to those listening, what we're doing here with this show is the first Thursday of every month you'll get Robert K. Last Thursday of every month you're going to get a bunch of different of us. We're all going to try to get in and meet you and answer some questions as we can for the time that we have.
Beautiful. It's so great that we could accommodate this just because we've had so many people write in wanting more of your show, which is amazing. We're in 7 cities. This show is our hottest show in any of our markets. So we are really glad to have you now the last Thursday of the month for the entire hour. Let's start off and you guys decide who is going to answer these questions. We're going to start off with some of your emails that have come in, and I don't think we're going to get to all of them tonight, but Peter, you and Michael decide who's going to take each question. We're going to start off with Bonnie from Boca Raton. She wants to know, are potential buyers allowed to attend a board meeting before purchasing a unit?
Mike, want me to do that?
Sure.
Basically, no.
Okay.
Board meetings are open to owners. Okay. Some boards are more liberal on that, but technically a board meeting is open to its unit owners. It's a private meeting. It's not a public meeting. And owners have a statutory right to attend, but no others.
It seems like people have a problem when they're not invited to board meetings.
People have lots of problems.
Here's Arnold in Boca Raton. He's a new board member, said he loves the show. He said, so if I understand this correctly, the board cannot have a closed meeting to discuss any issues we have and to invite the whole building. Is that correct?
Well, there's 2 circumstances they can close it.
Yeah, it's a bit of an overstatement. There is, as Peter just mentioned, there are under the statutes, there are 2 times a board can call an official meeting and close it to the membership. One would be if they're calling an official meeting to discuss personnel matters, and the second would be if they're and that can be with or without legal counsel. And the second would be if they're they want to have a meeting with counsel to discuss pending litigation, or I would say that's something you want to discuss with your counsel as to whether if you have issues that are discussed that you want to discuss, whether they might lead to litigation matters and require some attorney-client privilege. Those are the 2 areas. So if you're posting, you should still post that you're having a meeting of the board, but it would be posted as a closed meeting to address either personnel or those legal issues. And then the membership is not invited to join those meetings. All other official board meetings that are posted are all, as Peter mentioned, the membership of the association is invited to attend and can speak on agenda items at such time as the chair of the meeting designates. But that's it. That's those. So if we're talking official meetings, those 2 meetings are when the board can close and not have the members attend.
Well, apparently Arnold's a new board member. He wants to know, though. He said it seems ridiculous that every time we have to talk about something, we have to invite the whole building. And he wanted to know your thoughts on that.
Well, again, this is for the transparency. It's somewhat akin to the sunshine laws, which affect governments. They don't affect associations, but it's somewhat similar in that the owners pay assessments. The owners are entitled, to be in attendance at a board meeting and watch the board and participate by speaking when the board is making decisions. So, the law, is pretty clear. In fact, in my experience for doing this for a long, long time, I won't say how long.
Just say yourself. I saw that.
Long.
No, I've been doing it a long time. You've been doing it a long, long time.
long time. I find boards sometimes are too eager to close meetings. In other words, they want to close it every time they think it's something sensitive or something delicate, or they always use this other language. And I have to remind them frequently, as Mike just said, it's really just those two circumstances, personnel, and when you're meeting with counsel to discuss pending, proposed, threatened litigation, and you're seeking advice about that litigation. And personally, I think it's a good statutory provision where the owners do have the entitlement to be at that meeting.
Now, I will say, Steve, I will add to that just for the gentleman asking the question and a new board. First of all, two things. New board member, if you have not already, you should be at a board member education class, not just signing a certificate or an affidavit. You should attend a board member education class. Peter gives them all the time. I've given them now and again. Many of other attorneys do. They're free to attend. And these are the types of issues that are addressed for the ABCs of being a board member and to help board members understand what their obligations, the requirements, the things they are responsible for, the things perhaps they're not, as well as the role of their management if they have a management team, their counsel, etc. I do want to say a couple of years back, the statutes were amended, and it's now in 718 Condo Act, 719 the Cooperative, and 720 the HOA Act, which does specifically say that board members may communicate by email, but they may not vote by email. And to Peter's point, when the board is actually making decisions, making motions, taking action, and making decisions, those all should, whenever possible, and that should be just about always, be done at a properly noticed meeting of the board, open to the membership, where the members can, be involved in the discussion, the vote, the motion, the second, the discussion, and the vote. That said, common sense does need to prevail, and that's something that isn't always present in community associations. And what that means, in my opinion, and I will say that reasonable minds might not differ, but might look at this in different ways. But I will say that in my opinion, and I've expressed this on this show, I've expressed this at programs, I'm sure I've had this conversation with Peter as well, is in order for if the board is permitted to communicate. So that means, to this gentleman's question, if you have a contract that the board needs to vote upon, it's not expected that you're going to sit down at a board table, everyone's going to get handed the contract and say, okay, let's start reviewing, and sit there for 4 hours while you go over it and discuss it. You can review that. You can be communicating with each other, quote unquote, behind the scenes as to what you like, what you don't like, if you think you need more information, etc. What matters most, though, is that when you just make a determination which contractor you want to go with, and that's on an agenda item that the board is going to consider and vote on a contract for the painting of the building, for example, that discussion, that conversation, that motion is made, that second is had, and that conversation, the communications that might have been had before, I always say there should at least be some summary of what was discussed and the reasons for why you're going to make a motion and or vote in favor of or against a motion, so that those owners who have taken the time to either come out or if it's virtual to attend virtually are aware and can ask questions pertinent to what's going on. And to Peter's point, transparency. It's a word we preach, KBR, we preach it. But I do think there is that level of common sense. So my guidance, and oh, by the way, we should have said up front, this is not legal advice, guys. Informational. This is informational. But my recommendation is that if you have a question about, hey, can the board do this, discuss this, how can we handle this, reach out to counsel. If you don't have counsel, if you don't have counsel, you can get new counsel. Find experienced counsel that can assist you, and so that you do these things the right way. You're not necessarily handcuffed from having.
We already have we got a board of call. First night, board of call. Let's go to Stan in Palm Beach. Hi, Stan.
Well, my question is, the board raised the fee $10 in my HOA. I did not receive notification of such increase, and therefore I paid my January payment short $10. I received a notice for the $10, a $25 late fee from the community, and a $25 fee from the management company notifying me that I could be sued or sent to a collection agency. I paid the $10 and wanted to dispute the $50. In February, I got hit with another $50 fine. One, is that proper? Is it legal? Does the management company require to send out a collection legal notice twice or just once?
Okay.
Well,
You want me to go?
I mean, are you asking whether the increase in the assessment was legal or the way they're collecting it?
Question is, can I be charged $25 twice for the letter of notification that they're going to turn me over to collection agency?
Well, I can offer my what I'll tell
Right.
you again is the fact is that, first of all, based on the facts you've presented, I have some trouble that you're saying notification wasn't provided of the increase. Now you're saying you didn't, and we're not going to get into the specific facts respectfully. I just want to, because we just need to answer this generally. But if people were not properly notified, that could be an issue in and of itself, and it's disappointing to hear that you would say, hey guys, I never got notification, presuming you didn't, and that they're going to sit there and hit you with these quote unquote penalties on top of a $10 increase. But late fees on late fees, in my opinion, are not permitted. No,
Yeah,
so,
that's not permitted, and it's only one late fee per delinquency, so they
right.
can't
So if you
keep
paid the
piling
10
on.
bucks, if you paid that $10 and then your next payment you included the $10, so you were not late, there is no other late fee. They shouldn't be charging a late fee on the late fee.
I agree.
I've been hit with one $50 charge, and that's it.
Well,
You said it was a $25 late fee and then a management fee, which,
Well, the management fee charge is $25 for preparing the letter notifying me that my account can be turned over to collection or to an attorney, which seems ridiculous that they would do that on a $10 charge, but they say legally they have to do that. And then
Yeah,
the
they're
next
trying to-
month, they send me the same letter all over again, charging another $25.
right, well, and that's that other 25, and again, you said that after they sent you the first letter, you paid the $10, and then your next month, I presume, you paid the full amount, including the additional 10, because now you knew.
Yeah, exactly.
Right, so there should be no other $25 charge. It should have just been the one.
Okay, thank you,
So
Stan.
once I pay the 50, there should not be another 50 any other month. That's what I needed to know.
I mean,
Doesn't sound
unfortunately,
like it.
right. That's your easiest out. I don't like it. I don't like the way that story went down. I'm not a fan of the charges against you at all, but from the way you presented it. But if you pay that 50, you should be done.
Thanks, Stan. Let's go to our next call. We've got Susan. I think it's spelled wrong. Ciampa? Is that right? Hi, Susan.
Hi. Could you tell me
Hi,
the
Susan.
definition of a material alteration and if a large screen television or a portable grill are either one considered a material alteration?
Okay, this is always an interesting question. Okay, and this
Condo
comes
or
up-
HOA?
Condo.
Okay. Material alterations basically have been defined since the 70s in a case. It was a Sterling Village case. And basically, a material alteration is when you change the form, shape, elements, or specifications of the property in a manner that appreciably influences, affects, or changes the use, function, or appearance. That's a paraphrase. So it's basically
Pretty good
a material
paraphrase.
alteration is when you're changing the common elements or the association property in a way that's affecting in appreciable manner the look, function, or appearance. Okay. In your particular sample
Example.
or facts, they're adding a large screen TV and a grill. Now, ordinarily, I wouldn't think, and Mike might disagree with me on this, that's okay. Ordinarily, I would say that's probably not a material alteration. It potentially could be if they're changing the use, though, of a room. Like, for example, there's been cases out there where they made a craft room into a computer room or a computer room into a craft room. They changed some personal property. When they did that, they changed the use of the room, and therefore that was a material alteration. It was an appreciable change of the use. I don't know, was there, so under these facts, typically, ordinarily, I would say acquiring a TV or acquiring a grill would not be a material alteration unless there was something more into terms of that would turn it into that. I don't know, but Usually we get material alteration questions more with physical changes to color, use, appearance, things like that. This one, again, it will kind of depend upon, how much did the change of the use or the change of the appearance was affected by what they did. I'm leaning toward no.
Okay. All right.
Yeah,
Well, thank you very much.
I agree with what Peter said. I mean, the caveat I think we need to provide is if someone was complaining and it went up to the division, how would the division decide? That
Right.
But I think I agree with based on the facts you've provided. The concern I have is also the statute says we're talking about with material alterations. We're talking about some material alteration or substantial addition of the common element or real property. And
It's not real
TV
property.
and a TV and barbecue are not common element or real property. But that hasn't stopped the division from considering pool furniture as
Exactly.
or cushion.
Cushions,
You know,
they have the
so-
case on cushions. You change the color of the cushions.
Right. So it's I would suggest though that I 100% agree with Peter that that wouldn't be the case. We had a case a long time ago where there was a three-dimensional picture that was removed from a lobby, and an owner complained it was a material alteration, and we challenged it. We prevailed. Division approved. We appealed to the circuit. They approved. He appealed to the fourth, and then settled before the fourth could rule. But so that was a case which I felt was decided correctly by the division, but we have seen different things. So
Yeah. Ordinarily, the personal property would not rise to that level of a material alteration. That's correct.
right, shouldn't at least.
Does that answer your question?
We had,
It does.
I suppose our treasurer just purchased a large screen TV, and he didn't purchase just one because after he purchased one, he purchased a second one, bigger. And he claimed it was office equipment, but it's not located in the office. He wanted to project his treasurer's report on the screen. Well, the owners then, a group of owners asked, could they please have a portable grill? And they said, no, that's a material alteration. But the owners are arguing, well, why wasn't the television considered a material alteration?
Yeah. Yeah. I don't think the grill is going to be a material alteration, and the TV is probably not either. Okay.
Right. They're both kind of akin in use. Can I have a second question?
You may.
How many bids are required if you're doing a major project? How many bids is the board required to consider?
Multiple. The law requires you to have bids plural, which means at least two. That's what the law requires. Sound business judgment and ordinary business procedures, 3 is typically the minimum. And if you think about it, you want to get you get a bid that's 100,000, you get a second bid that's 50, and you're trying to figure out which makes more sense. You get that third bid that helps out. Large projects, many of my clients, Peter, I'm sure the same, will get upwards of 5 or 6, if there's enough interest out there in the project. So I would suggest in large projects like that, you're probably better off minimum 3. Law says 2. Law says 2, minimum 3 to 5.
I agree.
Okay. All right. Thank you very much. Appreciate your opinion.
Thanks, Susan.
Appreciate it.
Is that both HOA and condo, the two bids?
Yes, although the amounts when you have to get a bid are different, which is interesting. As far as the minimum amount of the contract, and in condo, if it's a contract that's more than 5%, of the budget, you have to get a bid. In HOA, it's 10. So it's interesting how they have that difference.
Well,
But the bid amount's the same.
okay. We're here with Michael Bender and Peter Mullengarden. We're talking community association law. We're going to go to break right now. Can one of you guys give us your phone number if people want to call the office?
Sure. The easiest number you can reach us, and just so you're aware, I should have said this, we do have 3 main offices. We have an office in Pompano Beach, we have an office in Palm Beach Gardens, we have an office in Hillsborough, offices by appointment in Miami-Dade. So you can reach all of those offices, 800-974-0680. 800-974-0680. And of course, info at kbrlegal.com is the email to reach us, and go to our website at kbrlegal.com. And there's a page right there if you have if questions, or if you're a board looking to consider a new counsel or additional counsel, you can reach out to us that way as well.
We're going to go to break. When we come back, we got so much more for you. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com, or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we're back. This is the Ask the Expert show, going on our 8th year. We're with you every Thursday night from 6 to 7 drive time. You can listen to us on your way home. And if you're just tuning in, we have added our most popular show, K. Bender Rembaum, who are with us the first Thursday of each month. They are now going to be with us the last Thursday of each month also. So you'll get both the shows now. If you'd like to call us up, if you have a question for our attorneys, Michael Bender or Peter Mullengarden, give us a call here at 888-565-1470. 888-565-1470. I just got a text, Michael, that somebody who is a board member who's come to a lot of your expos that you do, where you're speaking at, and said that you are a wonderful speaker. Now, is that your cousin or your relative?
Your mom texted. Yeah.
Thanks, Dad.
But actually, I got to tell you, because I haven't really talked to you in a long time, you get a lot of compliments. I don't know how many people you talk to after you've done your classes that you do, but people really enjoy how you speak.
Appreciate that. Well, and I will tell you, and I'm not just blowing smoke either, I get a lot of people telling me same thing about Peter, about Andrew, Emily, Allison, obviously Jeff, and who, all of us who go out and present our classes and do our webinars, get a lot of positive feedback, and we appreciate it. I mean, we're out there, giving the good education. We appreciate people following along and hearing what we have to say, and hopefully some of it, guidance helps. And obviously down the road, if these communities appreciate what we're saying and how we're saying it, they know they can get that every day if they want to bring us on.
Wonderful. Yeah. Speaking of that, you have a few things coming up, don't you?
Well, we do. I will tell you that I have a couple of things that I have coming up in June. And as we talked about, Robert will be on next Thursday. I guess that's June 2nd, and he'll be able to fill you in on more of what we're doing as a firm. On June 15th, from at noon, I'll be doing a panelist along with Jeff Rembaum, one of my partners, doing a preparing for hurricane season. That's gonna be live via Zoom. That's hosted by the Castle Group. And then a week later, June 21st, from 12 noon to 1:15, I'll be doing a live Zoom hosted by Campbell Property Management, discussing the recent legislative session, as well, which will also include the current legislative extra session. that they're having right now, and which ends tomorrow, and which hopefully will conclude, if not today, tomorrow, with governor signing a condo safety bill. This special session had to deal with insurance and the huge impact that the current insurance market in Florida is having on all of us. I mean, on a personal level, as I live in an HOA, but as a homeowner, though I'm getting hit. I was on the phone with a condominium association client on the beach in Broward, who reached out to me today that said, yeah, I was helping them because they're doing an amended budget effective July 1st because their premiums went up 96%.
No.
96%.
Wow.
That's they're one of the ones who still has a company offering them premiums. There's been and Peter, I imagine the same thing's going on in Palm Beach.
Yeah, it's a big problem. I mean, some associations are even scrambling to get any insurance. So yeah, it's a huge problem.
I want to tell you.
And unfortunately, but Steve, I said unfortunately, this session on insurance, no one should expect it to be a panacea of solving our current rate problems. It's steps. And I'm not even sure what they've approved thus far. If anything, hopefully by tomorrow, everything will be clear on the insurance side. But it's baby steps and it's little things, and really, it was really more to address individuals as opposed to the associations themselves. And it's a little scary, to be honest.
Let's go to Janet in Vero Beach. Good evening, Janet.
Hey, hi. Thanks for taking my call. I really appreciate it.
We appreciate
Hi,
you.
Janet.
Hi, Janet.
Hey, so just with what you were talking about, I was wondering if you could shed any more insight on what's going on in the legislature right now with respect to what inspections they're specifically targeting. Is it just structural? And on the required reserve side, what's going to be included in that? And I'll hang up and listen to your answer. Thanks.
Thank you, Janet.
Janet, what if I say no? Peter, I don't know if you have anything. I mean, I will say this: the governor hasn't signed anything
I've read
yet.
the bill.
Yeah, and I did too. It's 101 pages. But go ahead, Peter, if you want to share some of that. I just want to say the governor hasn't yet signed it. He's fully expected to sign it. It has passed the House. It has passed the Senate. And it is. And I will say just this before Peter gets into more specifics. I will say that. It is something. It's something. I'm glad they passed something. It is definitely, in my opinion, something that needs to be continued to be massaged a little bit, and we'll have a 2023 session to hopefully like I said, with the Florida Legislative Alliance that I'm member of, that working with the legislators closely to make sure that the potential negative impact on associations is minimized. From all the good stuff that this is going to do. But Peter, did you want to kind of go over the
all I'll say real quickly is as far as I know, because I got an email right before we came on the air where he did sign it. Okay?
Oh, good.
So my information is he has signed it. Now I read it quickly. Okay, so although we are the experts,
101 pages.
It is 100 pages, and I read it quickly. But Janet, there is going to be a requirement for what's known as a milestone inspection. It's going to apply to buildings that are 3 or more stories in height, condominiums and cooperatives. It's going to be a structural, basically, inspection review by engineer or an architect. There's a phase 1 and a phase 2, okay? And it's going to happen for buildings that are 30 years in age based on their certificate of occupancy, and then it's going to be every 10 years after that. If you're within 3 miles of the beach or the coastline, it's 25 years and every 10 years after that. But any condominium that was built before I think it's June 10th, 1992, I could be wrong on that, they're going to have to get the inspection by the end of 2024. It's going to be a structural inspection. The phase 1 is just a visual. If the visual shows there's problem, this is, by the way, a very brief summary. Okay, very brief. We'll get more intense on this later. But if there's any structural problems from the visual inspection, then there's a phase 2, where it's a more intense, where the engineer has to recommend what repairs are needed and things like that. On the reserve side, they are going to require what's known as a structural reserve study. Okay, that structural reserve study must be done every 10 years. Okay, the first visual on that also by a licensed engineer or architect. Interesting with the reserves, probably the last thing I'm going to say on this. The interesting part of that is they've now listed a whole list of things under what they consider structural, and that's and everything from the roof, from the structural members, waterproofing. It's a long list.
The foundation.
And the law is going to be that the associations can no longer waive the reserves or reduce the reserves for those items. That's going to start commencing at the end of 2024. So there'd be no more waiver of, and that's really broad. I mean, it almost includes anything but stuff that's just cosmetic, quite frankly, the way I read it. And that's going to have a huge impact, obviously, on associations, no longer being able to waive those reserves. They're also no longer to be able to use those reserves for other purposes. Typically, under the statutes, you can switch reserves from one purpose to another by an owner vote. That's been eliminated. So they're trying to lock in, for long story short, that they're going to have these reports, the structural condition, and requiring the reserves for these structural items without the ability to waive or reduce them and without the ability to move them around. Now, that's a very brief outline of what I think are the highlights of that statute.
Yeah. Then that was great, Peter. And it's in particular, there's a couple of issues I'll just point out for the listeners. It's brand new. First of all, let's also recognize it is 101
brand
pages.
New.
And it is brand new. So it needs to be digested. It needs to be processed. And it needs to be, it's going to need to be further addressed, in my opinion. To Peter's point there, when we're talking, what exactly does that mean with fully funding of reserves? And the fact, and you also talking about requiring these inspections by these engineers, and even these reserve studies by these engineers, and there's a potential. I think there's a definite issue of labor shortage, of having enough qualified people to do what this bill, once signed law, and by the way, according to what I texted our lobbyist Travis Moore, he said it's not signed yet. Governor will be signing though.
Your interest is better than mine.
So the idea here is though, there's enough labor to address some of these things as well, and so these are issues that I think need to be further vetted. I am hopeful, and for anyone listening in Tallahassee or anyone who knows anyone in Tallahassee listening, please be open to working with us at CAI, the Florida Legislative Alliance. We are a cross-reference of the industry. We have qualified attorneys, we have managers, we have CPAs who can help with the reserve study. We have reserve advisors involved, engineers. We have the whole gamut, and let us work with you on making sure this language is effective, positive, effective, which is what you want out of Tallahassee, but not to the extent that it's going to be detrimental or in some cases decimate. And I also don't want to get, because you have owners who are panicking or potentially panicking about, oh my God, we haven't had reserves in 30 years. Now we need to fully fund in 2. And I don't think that's what it necessarily, I hope that's not what it means. So we got to work all that out. The good news is
that's a good point.
Yeah. The good news is, as Peter mentioned, the effective date for these things, the reserve study in particular, is the end of December 2024, or I guess effectively January 1, 2025. But it does say, I think, December 31st, 2024. That means there are 2 legislative sessions prior to that. There's March of 2023 and January of 2024. So we do have opportunities over the next couple of years to work with Tallahassee, to work with all the industry professionals and massage this in a way where it is in place and effective. I'm very happy they're going to require the entire state to have these certifications that Miami-Dade and Broward were the only counties that had it. It's great that we're going to move forward with that. Condo safety is obviously the big part. I mean, it's a small, very small silver lining to come out of a tragic event in Surfside, but we do need to now make sure that this bill will be completely helpful and effective and not devastating, especially when we have the insurance situation going on.
Well, you're going to love our next caller. It's like one of our best callers to the show. Good evening, Barry from Miami.
Hi, how are you? One comment, one question. My comment is that KBR is the best. And I'm not a relative, and I'm not a cousin.
And you're not a client.
And I wish we were. I'm not on the board. I really wish we were.
Barry, didn't you used to be an attorney?
Yes.
That's what I thought. Okay.
You mentioned the huge insurance increases in premiums. And my question is, what do you think about the 115% budget rule? Is that a rule that, in light of the huge increases, really needs to go?
Yeah, I mean, I don't know, Peter, if you want to go, but I'll say this.
Well,
But,
I don't know. I've never been a fan of that statute anyway.
Yeah.
But,
I mean, the thing is, and that has actually recently come up. And of course, what Barry's talking about is something that's in 718. There's nothing in 720 to my recollection.
No, there's not.
And I don't know if it's in 719. Sometimes it gets left out, but it might be in 719. But we'll just say for purposes of this, in the Condominium Act, there's language that talks about if the board has a budget increase where the regular assessments are 15% or 115% over the prior year. Some, again, paraphrasing. That there's processes. It does not automatically. Like I had the question come to me yesterday. Hey, so if we have to increase this because the insurance premium and that's over the 15%, so now does that automatically trigger this obligation and we have to do? And I absolutely not. It is, there's still the requirement, the burden or the onus is still on the members who believe this budget is improper or unfair or not supported to make this challenge and to create an alternative budget and to present this budget at a meeting of the membership where quorum is established, where the members then vote on an alternative budget. There's a lot of steps in place that have to happen. The only obligation the board would have for the association is if I think it's 10%, if 10% of the owners do make that challenge, then the board has to agree to notice the meeting of the membership with proper notice, and then let the members, if they show up or don't show up. But
right,
again,
and if the members,
go ahead, Peter.
No, go ahead.
No, I was saying, but keep in mind, if you have a common expense, your insurance is a common expense, and you have an obligation to pay it. The alternative, in my opinion, if someone's going to come up with an alternative budget, they have to be able to address all the common expenses of the association. They can't come back with a budget that's going to leave the association in the red.
Yeah, exactly. And also, speaking of insurance, the statute says you must use best efforts to insure the property up to its insurable value. Okay, so I don't think you can look at the 115% statute, which rarely gets invoked. I think I'm doing this for 30 million years. I've been doing it. I don't think I've ever seen a budget get overturned from the 115%. Okay,
one.
Yeah, had you one?
You had one in 20 plus years, and Robert too, saying the same one. Yeah.
My 30 million years, I haven't seen it. But quite frankly, if you have an association that must insure, and the statute says you must insure, I don't know if this has ever really come up, but I'm not saying it's a conflict necessarily, but I'm going to err, quite frankly, personally, every time on you pay that insurance premium, and I'll deal with that crazy 115% later, because that's the lesser of the two evil in my view.
I agree with you. And here's another thing, Barry. What a board can do if an owner really wanted to challenge that, and enough owners really want to challenge it. All right, well, we're not going to increase the regular assessments. We're just going to do a one-time special assessment.
We'll just do a one-time special to address this operating shortfall because of this unanticipated large increase in the insurance premium. They don't need a vote of the membership to do that. So if the board is trying to do it by way of a budget or an amended budget and spread it out over several months, that's within the discretion of the board. But if enough owners want to challenge it, hey, you can't do that. All right, well, we'll just adopt a special assessment and ask everybody for a large chunk of money right now. I mean, there are ways around it. So, I mean, question's good, Barry, but and I agree with Peter. It's something that is so rare. I mean, so rare that I don't know that it's even worth having to address it in Tallahassee, but it does seem silly.
Thanks,
Great.
Barry.
Thank you very much.
Thanks,
Great.
Barry. He's a great caller. We got to go to break. Give everybody your number, Michael.
That number again is 800-974-0680, kbrlegal.com. kbrlegal.com. We have a lot of great tabs there, a lot of resources, and there's a bar there that you can submit requests for consultations or questions. You can email us at info@kbrlegal.com.
Great website. It's got so much information on there. We're going to go to break, and we'll come right back for our last part of our show.
Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. If you
Steve,
are confused, yes.
hey, do you have that special breaking news kind of sound for us?
Breaking news.
Breaking news. You guys are hearing it first. I just got the info. He just signed the bill.
He really did.
It is now law. He literally
sure.
just signed it with about 2-3 minutes ago, like right as we went.
See, I was correct just early.
You were.
You know what? You were one of those mediums.
Nostradamus.
You're a witch.
I'm a
You
witch.
heard it here first.
Thanks.
Hey, let's go to Bonnie in Coconut Creek. Hi, Bonnie.
Hi. I have a question for the panel. When you're dealing with an architectural review form or architectural review committee, and a homeowner, you're in an HOA, there's an HOA, which has a master and also several subs in there. In our particular case, the architectural form goes to the sub first to be looked at and reviewed, but it's the master who is the only one that has a committee who passes it. What I'm having difficulty analyzing, and thank you, KBR, Lisa, for giving us some information. What I'm asking is, it's the follow-through that I'm really finding difficult. When the master fails to follow through, what can the sub do when they didn't actually approve it?
I know who this is. How are you?
I'm well, thank you.
Good. Speaking more generally, not to yours, because really your documents are going to offer some guidance, and I know you know this, Bonnie.
Yeah.
So if the way the documents are drafted, that the master is the one who is responsible and has control, then I don't know that the sub has any authority or any ability to do anything. Really, that's just the way that's really something that has to be looked at, is the way the community documents were set up. And there are situations where you have a master and several subs, and the master is the party responsible because they want to ensure uniformity throughout all of the subs, and they don't want different subs having different architectural guidelines.
Yes.
But I will say that typically what I've seen is as long as the guidelines, the sub could have guidelines that the master approves, and then the sub could, which is like the master may say, this is what we require. If you have any additional requirements, we'll approve those, and then you can be more strict than we are, for example. But that's something that would really be dependent on the relationship, the governing documents, and the relationship between the parties. I don't know if Peter, you have anything more to add on that?
No, I was
I'll
going
give you an
to
example.
basically.
Okay. I was just going to give you an example. For example, the master approves a house being painted white with gray trim. And then the homeowner turns around and instead paints it blue with pink trim. And the sub wants the master to do something about it, and they don't.
This is completely document driven, as Michael said, and it really depends which party or parties have the authority to approve that change. Okay. And then which have the authority, quite frankly, to pursue it if it's not done correctly. One thing that that all the listeners have to be aware is, we're on the radio and we're giving very general answers, but oftentimes the true answers would require a review of the documents, analysis of the documents, and applying them to the facts. And sometimes on a radio answer, and it's very difficult to dive that deep. But here, this would depend upon who really has the authority to approve and control architectural change. Sometimes it's both. In some master sub communities, you have to get approval from the sub and the master. In some, it's just the master. In some, it's just the sub. So, that's a kind of a long-winded answer, but it really depends upon who has the authority to approve and who has the authority to enforce.
Right. And I will say the other thing to add to that is, and to your specific issue, if the master does not want to pursue for whatever reason, then the master could perhaps assign its authority to do so to the sub and let the sub take it. Again, that would be something that the documents may permit, or it's something that could be worked out with counsel. And because that could be, maybe they may just say, hey, listen, this is what we require. If someone breaches it, then you sub take on the aggravation and the expense of enforcing it. That is another option too.
Okay, thank you.
Wow.
You're welcome.
I got to tell you, this hour has gone by so fast. We're at the end of the show. We've been here with Michael Bender and Peter Mullengarden. And I apologize to all the people who are on hold right now. We'll be back again next Thursday with K. Bender Rimbaum. I'm sure it'll be Robert K. But now you've got it the first and last Thursday of the month from 6 to 7. Michael, like old times, you were wonderful. You and Peter both were wonderful. Let's give everybody your phone number before we leave.
Right. Okay. Well, let's say this. I'm gonna start with this. KBRLegal.com, guys. Go to the website. KBRLegal.com. Go to the tabs. We have Legal Morsels. We have Rembaum's Roundup. We have lots of guidance and links to webinars that we've all done. So there's just a boatload of education and information. There's also obviously information on the firm at kbrlegal.com. As I mentioned earlier, if you like the answers you're giving, if you like how what we hear from Peter and I can assure you this is just the way all of our attorneys are educated and share information. And so you can reach out to us through the website, hit a submission form there if your board or management team is looking, if the management team is assisting the board with looking for counsel. Info at kbrlegal.com is another way to reach us.
Out of here.
And,
thank you guys so much.
974-0680.
Thanks, Peter.
Hey.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.
The opinions expressed